Hello, I'm Bob Fitzpatrick, and I'm going to talk for the next hour or so to you all about federal Civil Rule 35 mental exams in employment cases. That in and of itself was a mouthful, okay? First of all, we're under the federal rules. I'll briefly talk in a minute about state rules. We're only talking about mental. Rule 35 deals with physical and mental. Physical exams have been around. I mean, Rule 35 been around since slightly before 1940, but physical exams rarely come up, except maybe in ADA cases, but rarely come up in employment cases. Mental exams have really taken off in employment cases in the last decade. So we're going to be talking about employment cases, mental exams. Let me quickly, the slide will have a disclaimer on it, but let me just quickly, in simple terms, explain the disclaimer to you. If you are stupid enough to rely upon something that I say or something that's in the slide deck, and I'm dead wrong, or the courts have evolved beyond where I'm at, or my slide deck is deck wrong, it's your fault, not mine. That's the simple explanation of my disclaimer. Okay, you need to be familiar with Rule 35. Some of the text of it is in your slide deck. The important parts are three, okay? One, and I'll talk about this at some length. One, the mental condition of the person being proposed to be examined has to be, quote, in controversy, not at issue. That's a concept very different than in controversy. It may be, and we'll discuss this, it may be that it's not in controversy. It may be what's called garden variety emotional distress, but it still is at issue because it is pled as a damage, garden variety emotional distress, for example, and therefore raises issues about discovery of medical records, et cetera, all of which I hope we'll get to. Number two in the rule is there is a requirement that there be good cause for the mental exam. That kind of goes in most cases hand in hand with in controversy, okay? And then thirdly, and this will come up at the end of our discussion, there's a 1991 amendment to the rule that added the language that the examination can be by a, quote, suitably licensed or certified examiner. Okay, what the heck does that mean? Well, the defense has argued, and for the most part successfully, that that language now means that a vocational rehabilitation expert can conduct an examination of the plaintiff in an employment case under Rule 35. I'll discuss that at some length, I hope, near the end of our discussion here. Suffice it to say, it's a very underused tactic by the defense. In my judgment, should be much more utilized by the defense because it bears on employability, mitigation, and most importantly, the amount of damages that can be awarded. It may affect the jury, even if it doesn't affect the jury, it may affect the judge on a request for a remittal or to reduce the amount of a damage award because the voc rehab expert has testified about skill set, employability, et cetera, et cetera.